All right, we are live and recording. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justice of the Massachusetts Appeals Court, now sitting virtually within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you, and good afternoon, everybody. We're here on 2021 J31, Department of Children and Families versus Father. This is the father's petition under Chapter 231, Section 118, first paragraph, for review of a 72-hour hearing held by in the juvenile court. Is the juvenile court, right? Yeah,
That's right.
Remind counsel that this is an impounded case, so don't refer to anybody by names. You know, we can refer to the child, the mother, the father, paternal grandparent, maternal grandparent, whatever the case may be. Avoid using names. And so I've read your material. I've got a petition from the father. I've got a response from the department. I have a response to that from the father. I've read all those materials. I will confess I did not read the transcript. I will if I have to. But let me, and not to hide the ball, let me tell you what my initial impression is, and I have you react to that. My initial reaction is that I mean, there's two things that the father's asking, or there's two determinations that were made. One is whether, at the time, by the proponents of the evidence, it was appropriate for the department to take custody of the child, and the other is whether the department made reasonable efforts to reunite the child with, in this case, the father. I think the father was asking that I should immediately order the department to give custody to the father, so I'm not inclined to do that. I'll tell you that right now. I'm not inclined to issue an order today doing that. However, I think that the showing of reasonable efforts is very lacking, if not non-existent, and so I think that some remedy is required because of that. So, with knowing now that you know where I stand and what I'm looking for, if you could feel free to correct me if I'm wrong on any of those. But why don't I start with Attorney Chayette, and then we'll hear from the department.
Thanks, Your Honor. So actually, I'd like to reframe a little bit the way you put it. The question, the reasonable efforts question, isn't about reunification. The reasonable efforts question is about family separation. There's very little judicial review of this particular question, and I don't want to get too far off stream. But on direct appeal, if there's a trial on the merits, the question whether the department made reasonable efforts to avoid family separation in the first instance, that never gets reviewed on direct appeal. So the only way that gets reviewed is through a single justice petition, and very few of them do, and very few get reported out. And so it's a sort of the same ball of wax, but coming at it from a very different perspective. And so that reasonable efforts question is material to the emergency removal of the child, of any child, but of the baby in this case, and to the emergency custody order that the department obtained 3 days after the emergency removal. And I appreciate that Your Honor was persuaded that there was no reasonable efforts. I mean, we've got a 51A that comes in around 5 o'clock on November 27th, alleging that we don't know where the baby is, and it's the maternal grandmother who's got a contentious relationship with the mother and father, who's the source of the information that we don't know where the baby is. And 2 pages deep into that same 51A, the maternal grandmother is the source of the information about where the child is. And within 90 minutes of receiving that, without making any call to the father, whose contact information the department had in hand, the worker is removing this child on an emergency basis. And the professed basis for that is that the department didn't have enough information about this caregiver. In fact, she was known to the department, at least to some degree, and there was no suggestion that this wasn't just like a random person, you know, with that mother had left the child with some random person on the side of the road. It turns out this woman is an authorized supervisor of kid visitation through the probate court and well known to the family. And in terms of, go ahead.
I want to get my bearings a little bit better. So at the time that the emergency removal, custody was with the mother, right?
Yes, but so dad is a non-custodial. They're not married.
Right.
And so the child was in the mother's custody, although when mom went back to work after the baby was born, there was a period when, you know, dad was taking care of the baby, you know, during the day when mom was at work. And just to remind you, there was a 51A and 51B done at the time of the child's birth in August. And while the case was opened, everyone was clear that there was no worry of abuse and neglect. But, you know, the parents had issues. And so the department had stayed involved. But so yes, the mother had custody. She was arrested around midnight just after midnight, November 27th. She had, the baby was being babysat by this woman, Ms. Brantley, this, you know, authorized supervisor and a close friend of the family. And as I said, identified to DCF in August during the whole 51A and 51B. And that's where the child was. There was testimony from the father that he and Ms. Brantley had spoken, and the plan was he doesn't have a license and nobody that he lives with has a license. And the plan was that she was going to bring the baby to him at his mom's where he lived at the end of the day.
Okay, so
before that could happen.
So he's living with, just to make clear, he's living with his mother. And is he still at this point today?
Yes.
Okay. And she was living in her own apartment, or?
Yeah, in her own apartment in Holyoke. So she has an apartment in Holyoke that's now vacant since she's incarcerated. He lives in Springfield with his mom and I think it's his nephew. And he's been at that address with his mom. He and the mother, while they've continued to be involved and have been co-parenting, they haven't been living together for well over a year since he'd gotten out of jail from a committed term in November.
The mother is still incarcerated today?
That's my understanding, yeah.
And that is it, Your Honor. If I apologize for interrupting, but she is not incarcerated, Your Honor.
Oh. So, I guess I thank you for giving me that information. What is the mother's status at the moment? And maybe I'll ask the department later, but does the mother have the child now?
No.
No.
Okay.
The child is still in the care of the department, is my understanding.
And what was the mother? She was arrested for violating a 209A. Is that right?
Correct.
And what's the status of that case?
That's mother intends that to be dropped the next time she's in court, which I believe is in about a month.
No, but she's the defendant in the one that she violated.
Yes.
She can't drop that one. What's the status of the criminal case there?
The criminal, I believe the person who filed the petition against her is dropping that.
Okay, that's what you said.
Yes, now she's dropping it, but
okay. All right, thank you. Go back to Attorney Chad.
So this reasonable efforts, going back to the reasonable efforts question. So then it's this 90-minute within 90-minute removal, and I don't know if I mentioned this, but that's actually even accounting for the fact that the social worker went to the wrong address first, apparently. So this just happens like that. There's no effort to call the dad. Ms. Brantley calls the dad while the social worker is there doing the removal. The social worker sort of rebuffs that efforts. And then 3 days later, the department goes into court and gets an emergency custody order. And in that's based on the affidavit. So the petition, the affidavit, which is in the record appendix, that wasn't before Justice Dunbar at the temporary custody hearing, but it was before the court on the emergency custody hearing. And that's when the court makes that initial reasonable efforts determination. That's when a court says you did everything that you needed to prevent family separation. That petition doesn't say anything, make any allegation about the father. It has very little information about him. It does have some somewhat disparaging comments about the father and about Ms. Brantley from the same maternal grandmother who said, we don't know where the child is. We know where the child is on the 51A. And that's when that first reasonable efforts determination is made. It's then revisited at the 72-hour hearing, which in this case was a month later. But so that's the reasonable efforts. So there's the question of what reasonable efforts means prior to separating a family. It hasn't been decided. It hasn't been defined. But Justice Massing, you don't have to be the judge who defines that standard, because where nothing was done, where no call to the father was made, they can't possibly meet it. Where the child was in the care of somebody who is competent, at least in the moment of an emergency, to care for the child, there was no effort made. There were no reasonable efforts at all. And so that's that
Let's
issue.
ask you then, what, short of returning the child, or actually not returning, placing the child in the father's custody for the first time, what type of, assuming short of that, but looking towards reasonable efforts, what sort of efforts would you like to see the department making for your client?
Well, that's the thing. This is not, so many of these reasonable efforts claims are about what kind of support did the parent need in order to regain custody of their child, right? This is, if the department had simply picked up the phone and called the father and said, where's the baby? And he would have said, the baby is with Ms. Brantley and she's bringing him to me at the end of the day because I don't have a license. Well, then that's what happens. And the baby goes to the dad. And then DCF, there's an open case. DCF can visit him, make sure he's got everything that he needs, that the house is safe for the child. But there was no reason to remove this child on an emergency basis. And so that it's sort of, there was no suggestion that the emergency service plan that the department produced right after the baby's birth in August, that he wasn't compliant. I think they'd asked him to do, he's never had a substance abuse problem, but I think they asked him to do that. He did that. There were a couple things that they asked him in that outset, and he'd been doing them. But one of the concerns that animates these kinds of cases, and you said something a moment ago, I mean, we don't require, a first-time parent has a baby at a hospital and leaves, right? They might know nothing about caring for a child. There's not an expectation that the presumptively fit parent who hasn't had a child before doesn't need services in order to know how to and learn how to care for a child. And in this case, in fact, the father had custody of one of his older children, and following the baby's birth, he had been caring for the child, changing his diaper and doing all of that. So I don't think there's just, the department needed to do something, and they did nothing. And so I don't think I can't articulate a service or something other than making that call. The department says, well, we didn't know whether the babysitter was safe, but the department didn't have custody of this child. There was no obligation on the parent's part to call DCF and say, is it okay if this woman babysits my kid?
But I can't order them to go back in time and make a phone call.
No, they can't. But what you actually do have the authority to vacate the custody order. And that can happen. It does happen, to vacate the custody order, because not only did they not make reasonable efforts, but then when you get to the temporary custody hearing and ask whether, and I'm so sorry I'm hoping that she's going to settle down. I may actually have to let her out. That was there actually evidence by a fair preponderance of the evidence that that the child would be at immediate risk of serious abuse or neglect if placed with the dad. The social worker says, no, I agree there's no immediate risk. I agree the dad can provide physical care, medical care, and emotional care. And so certainly, I mean, it's the combination of these two things of having done nothing to prevent separation, and then the absolute lack of evidence of that immediacy of harm and the seriousness of harm that really does warrant vacating the temporary custody order. And obviously, again, the case continues. DCF stays involved. DCF continues to monitor the parents. DCF visits the mom's, the paternal grandmother's home where the father is living. I mean, that's what ought to happen. And I know you're looking for something else. But in these kinds of circumstances, I mean, we could remand for a new trial temporary custody hearing, but I mean, that's just an odd result given the complete absence of evidence. And it does seem enormously unfair to a parent who's not been demonstrated to be unfit or unsafe for his child.
Yeah, I know there are other children. Has there ever been an adjudication with respect to those children and the father?
No. If he had been adjudicated unfit or if his rights had been terminated, this would be a very, very different case.
Right.
The other children, his other kids, are in the permanent guardianship with the maternal grandmother, and there are ongoing probate court proceedings because the father and the mother have been trying to get the kids back. And so that's a little bit, I think, what's animating some of the grip between the maternal grandmother and the mother and father separately, because she has he's got a 4-year-old and a 15-year-old. And bear in mind, he was in jail for a few years, so that was a lot of what kept him from having a lot of contact with the 4-year-old in particular. But he had been having regular contact with her. There's been, again, issues with the maternal grandmother. And again, this woman, Miss Brantley, she was supervising the visits in the proceedings of undoing the guardianship with the older kids.
All right. Well, thank you. I think I understand your position here. Let's hear from Attorney Murphy.
I'm just going.
Thank you, Your Honor. I think to characterize the department's efforts as non-existent is definitely not complying with the record and what in fact happened here. The department had an open case with this family for 2 months before it removed the child. We were providing case management services, daycare referrals. We arranged for therapy for father, which I might add, despite his exhaustive and lengthy history of violence and criminal behavior, he had never engaged in therapy. His own testimony, he admitted he had never engaged in therapy before. So this was a very crucial component of this for the safety of this child. In fact, the social worker testified, and the documental evidence shows that the department was very concerned about domestic violence and anger management. And therefore, father's participation in services is very important on that issue. And I'm not sure that there weren't a lot of options at that time when the child was left with a babysitter for 15 to 17 hours. And no one knew where this child was. For the department to become concerned at that point was completely reasonable.
Well, I mean, so isn't it, actually though, didn't the maternal grandmother knew exactly where the child was, and the mother knew where the child was?
Well, the mother was in jail, so
Yeah.
we were not able to contact mother and find out. The paternal grandparents or paternal grandmother, maternal grandmother, and other family members did not know where the child was. When the initial 51A report was filed, no one knew where the baby was. So at that point, now the record is not clear whether the department attempted to call father. Father did testify that didn't happen, but the Department of Social Workers said he did not know whether the department attempted to call father. Now, certainly,
Well, was there anybody involved in the, was there anybody involved besides the social worker?
oh yes, there was a case management team that reviewed. What happened was, once the report was received, the case management team and the supervisor reviewed the documentary evidence that the department had on file, which was extensive because the department's been involved in this case for a very long time, on and off. And the decision at that point was made to remove. Now, after that decision was made, when the social workers were assigned to remove the child, the grandmother called and said, oh, I did find where the baby is. But that wasn't the information that was before the department when the 51A was filed. The family was concerned because no one knew where that baby was the whole afternoon, from the morning until 5 o'clock in the afternoon. And it wasn't until after that time that the department received information, oh, the child is with this friend who was supposed to be acting as a babysitter at that point. I'm not sure what other efforts the department could have made.
So the father says that the babysitter was actually somebody who was known to the department as a qualified supervisor. You don't acknowledge that in your materials.
No, because the department did not have that information. That was I understand from father's testimony, not from the record evidence, but father testified that this is a woman who supervised his visits that were allowed through the probate court action, not through us. The only information we had was in one of our reports, I believe it was maybe a 51B, that said that this was a friend of mother's who she used as a support, but we didn't have any other information concerning this babysitter, and none of that came out until the 72-hour hearing.
Do you have it now?
Pardon me?
You have that information now?
Only through father's testimony. There was no other documentary evidence before the department, and by the 72-hour hearing, I think the evidence, there were 10 exhibits entered into evidence, and the evidence definitely showed by the preponderance of the evidence, as the trial court found here, that the child was at risk. In fact, she made 3 points: that the father had little involvement with his other children, which he had 2 other children. And in fact, there were 4 other children that the department has been involved in. This, and again, mother has a lengthy history. In fact, she even, in one incident, left one of the children, not this child, but another child with a babysitter, and didn't pick that child up. So there's definitely a history of involvement here, as the court found. Let me go back to the 3 points that the trial court found here. That father had little involvement with his other 2 children, that there was domestic violence was a concern of the court and continued to be, because right after father was released from prison, there were 2 additional reports of domestic violence. And even after the department was involved with father, had him sign a service plan, said you're not to engage in any domestic violence, you're to get in therapy and do all this. He signed that, agreed to it. And then after that, there was another incident where mother alleged that he broke down the door to her apartment. So this was an ongoing concern, and the court notes this, the trial court notes this. And finally, again, the history here makes a big difference. We have a very young and very vulnerable child who cannot speak or communicate at 2-3 months of age. This is a very risky situation. And you have an extensive history with both parents of instability, involvement with domestic violence, criminal behaviors, repeated incarcerations. I think the trial court absolutely acted appropriately in continuing custody with the department. And the department continued to work with both parents, will be working with mother if she's released, but has provided case management services from before the removal and continuing. There's just no other services the department can possibly provide.
So what's the status now, and where's the child?
The department continues to work with father. I believe that father was looking for his own apartment and the department is continuing to work with him. He continues to cooperate. And as the judge even pointed out, she commended father for cooperating and being open to services. And he may, once the situation stabilizes, he may in fact regain custody of, or the child may be placed with him. But that remains to be seen.
Is the child in a foster placement now, or?
Yes, he is. Right. And then the department's also looking for, unfortunately, the maternal grandmother who has custody of the 4 siblings cannot take care of this particular child. So we are continuing to look at other relatives, including father's family. But right now, I believe, yes, right now the child remains in a foster placement.
Okay. I'm gonna break my rule, and I'm gonna actually just want to hear briefly from both counsel for the mother and the father, mother and the child. But do you have anything else you want to add, Attorney Murphy?
I will rest on my petition unless you have any other questions for me.
Not that I can think of at the moment, but can I address Attorney Moraes? And can you unmute yourself, or does the clerk?
Yes. Okay, there I go.
And so what's your position on this?
Well, my position, Your Honor, was most of the evidence in the documents, the 51As, were against mom. A lot of her behavior and her mental health issues have come to the forefront over the years and have caused issues for the family, but not a lot against the father. And the social worker testified during the hearing that he thought that the father on his own could care for the child, and that it was mother that was an issue. So he testified that he thought father could do it. He testified that father was appropriate and loving and caring during visitation, and that visits were going well. He lives with his mother, and his father testified that his mother could help care for the child. So I did support father at that time. And the child is in a non-kinship foster home.
And you said you supported the father at that time. What about today?
Yes, I would support father.
Okay, so you would be in favor of an order just returning or giving custody to the father today?
Yes, with continued participation with the department. Yes.
Okay. Thank you. I appreciate it. With
Thank
unprepared. And Attorney Walsh, do you want to add anything?
Yes, thank you, Justice Messing. There are a couple of things I want to add. One is that mother was released from incarceration on January 12th, has been out since, and maintains the same apartment she had at the point that this matter was brought into court. You may note that the record reflects that mother has said father could use her apartment were he to get custody back. But he also has the place where he lives with his mother and would have the support of his mother where the baby returned to him there. Secondly, Your Honor, in the probate action, DCF participates. So there's a social worker involved in the probate case that should know that this woman babysitter is an authorized caretaker for this child.
What is the probate action?
Mother and father have filed a motion to revoke the guardianship and to, in addition, to get parent-child parenting time that has been restricted by the maternal grandmother. So she was authorized by the judge in the probate case, I believe over a year ago, so that this woman was taking the child to her when she was incarcerated. And since she was released from that incarceration, that woman has been authorized to supervise visits, to transport the child, and to assist the mother.
Okay, so there's a probate action to remove the maternal grandmother and
as guardian of the youngest child and allow mother to regain custody.
Okay.
And in that action, DCF social worker has appeared. To my recollection, every time it's been in court since this case was filed.
So does the mother want the child returned to the father or to her?
She waived her temporary custody hearing, Your Honor, because she was incarcerated at the time. She was under the, I know you've gotten the flavor that there's an enormous amount of animosity between the relatives. And mother believes that the allegations against her were based on that animosity, which is what caused the restraining order and the violation of the restraining order. So because she was incarcerated, she is happy to assist. She is attempting to regain custody herself through the department by cooperating and has been cooperating.
Okay. You know, Attorney Chayette, you know, normally we don't have rebuttal in the appeals court, but anything you'd like to add? You got to unmute yourself.
Thank you, Justice Massing. Just briefly, a couple of responses. One, the 51A, wherein the maternal grandmother said, we don't know where the baby is. RA 268 shows an entry from an hour, less than an hour after that 51A came in, where the maternal grandmother says, this is where the baby is. So it is all in the same piece. And the fact that Attorney Murphy said, we don't know whether the father was called. The fact is that even if social worker Solano, the department witness, didn't personally, I mean, he didn't call the father, but he's the witness for DCF and he's charged with knowing what DCF did or didn't do. And you can't really just make up stuff. Well, maybe the department didn't disprove that they called. There's no evidence that they called the father. And there's certainly nothing in that petitioning affidavit supporting the emergency custody order, suggesting that anyone tried to reach out to him. And I would just finally reiterate that everything that the department is offering you, none of it goes to an immediate risk of a serious abuse or neglect. And you can't, the words of a statute can't be stretched beyond their fair meaning to relieve against what may appear to be a hard case. That's actually a quote from a 1933 SJC case that I found in doing some other research. But it really, the statute requires a risk of, immediate risk of serious abuse or neglect. And looking at all of the history doesn't establish that. And you can't, I don't know how they can get past their social worker's own testimony that this father did not pose any such risk. And so unless you have other questions, I'll also rest on the filed papers.
Thank you. And again, against protocol and tradition, Attorney Murphy, do you want to have anything you want to respond to?
Yes, in closing, I would just say a lot of this we went off the record, which is not surprising given that Your Honor would want to know exactly what the current situation is. But the facts is
I'm going to step in and do something now. Unlike a usual appeal where I am just stuck with the record here. If I'm going to step in, I got to know what's going on. So.
Oh, absolutely, absolutely. But I just would like to say, when you look at the 72-hour hearing, the evidence that was entered at the 72-hour hearing, the risk that was established, again, 10 exhibits entered without objection, father's own testimony, which the court did not credit at points. The social worker, unfortunately, was not an experienced social worker. He had only been on the case for 4 weeks. This was his first trial that he testified or hearing. He was not the most helpful witness, but the documentary evidence absolutely supports what the trial court did here. The trial court was looking at a situation with a lengthy history. Again, I would direct your attention to those 3 factors that the trial court found here: that the father had very little involvement with the children, very disconcerting, lengthy history of domestic violence, and again, lengthy history of family dysfunction, and a very young, vulnerable child. I think the trial court acted absolutely appropriately and with the child's best interests and safety in mind. And if there are no other questions, I will rely on my petition, my response.
Okay. No, I thank you all. I appreciate you all taking the time to help me sort through this. It's it's complicated. And I'll do my best to come to a fair conclusion as soon as possible. So with that, I think we'll adjourn. Thank you all. Have a good
Okay.
afternoon. I hope
Thank
you all
you very
keep your
much.
power and get your vaccines quickly.
Thank you.
Thank you, Your Honor.